I can lead you through it. I mean, here's the situation that where we stand now. Mr. Sidhu received a couple of years ago a letter from the CBSA saying they were considering his case, deciding whether or not to send him to a removal hearing. A removal hearing would result in a loss of his permanent resident status with no right of appeal because he got a sentence longer than 6 months. So we made extensive submissions to the CBSA. They were kind enough to give us extensions and allow us lots of time to make those submissions. We probably put in about 650 pages of submissions and supporting documents. They took over a year to make a decision. What they did was and after about 8 months or 9 months, they actually wrote to us and said, do you want to update your submissions? It's been a while. So we did. I mean, I think they were bending over backwards to be seen as being procedurally fair. But then in the end, they came out with a decision that was, no, we're going to send this case to a hearing, which means the end of permanent residence status for Mr. Sidu. So we challenged that decision in federal court. And it's that decision that has just come out, been issued by Chief Justice Crampton recently that says, no, I don't find that there's been any breach of procedural fairness or that the decision is unreasonable. And he also makes pronouncements about what he thinks the state of the law now is, particularly in light of a federal court of appeal decision in Oba's again one, which came out in June. So anyway, that's really what's shaken up the legal front here is the federal court of appeal decision, which he says, which Chief Justice Crampton says, well, that basically settles everything. You don't have any rights as a permanent resident. It's there is no real process here other than it's like a rubber stamp.
And Obaz is going, like, they're trying to get leave to appear before the Supreme Court of Canada. Am I right? Like they're still awaiting a leave decision.
They are. So I think they made that argument in October is what I understand, and are still waiting for the Supreme Court to make a ruling on that. The Supreme Court only accepts a very small percentage of leave applications. And, I kind of read their weekly summaries and it gets discouraging that usually when it's an immigration case, they don't get leave. It's very, very rare. So this is what I think there should be leave. I think that the Federal Court of Appeals got the law dead wrong. But I'm not the Federal Court of Appeal or the Supreme Court. And so we're going to have to live with what comes out of it.
So I think go step by step. Like if someone is a permanent resident of Canada, they've been convicted of a crime that constitutes serious criminality, and they serve a sentence that's more than 6 months, like Mr. Sidhu. What are the actual steps that occur? I posted to social media that we would be having you on, and most of the questions that I received involved kind of people wanting to sort of understand this process. Was the first batch of questions. So why don't we start with that? Like someone is just been, well, so first, like, I guess, do they go straight from jail to the airport, or what are the actual steps?
Okay, so to put in some context, let's talk about the way it works for permanent residents in general and how it worked before they changed the act to take away appeal rights. So it used to be that a permanent resident who was convicted of a serious criminal offense, regardless of sentence, would have a right of appeal. So they would get a deportation order. The CBSA would decide whether or not to send the case to a hearing. If they decided, yes, it's going to hearing, then it would go before the immigration division. And then they would have a right of appeal on humanitarian grounds, really considering all the circumstances of the case. In 2001, when they brought in the new Immigration and Refugee Protection Act, they said in certain cases, you will lose that right of appeal if you have a sentence, a prison sentence of more than 2 years. That's where they drew the line. They said that there would be a full review by immigration officers before those cases were ever processed. That would be the substitute. But what the Federal Court of Appeal has just done is said, no, they didn't really mean what they said they meant. That when they said that there would be a full review, they didn't really mean that. What the statute means is there is no full review. So now the process is that for the people like Mr. Sidu who have served over 6 months, CBSA is supposed to review the circumstances of the case according to the recent decisions, including in the Sidu decision. That review is basically a fact-finding mission, which was their conviction or not? Is he a permanent resident or not?
Whereas
And
before, it was both, if I'm understanding, CBSA could look at someone's personal circumstances and also at the appeal before, they could look at someone's personal circumstances, also known as humanitarian and compassionate factors, which is no longer the case.
yeah, it was actually based on a case called Ribic, R-I-B-I-C, that has governed this process for a very long time, which was to consider all the circumstances of the case. They didn't actually use the words humanitarian compassionate in that, but it was like the seriousness of the offense, the level of remorse, rehabilitation and prospects for rehabilitation, strength of your family ties in Canada and your other successful establishment, and what hardship would be suffered by the individual or by family if they were to be removed from Canada. And of course, the overarching concern always that comes into these is best interests of any child who's affected. Essentially, what the court has now said is that's not what an officer does, even though that's what the minister's representative said the officers would be doing. That's no longer the case. So there will be no review. Basically, Chief Justice Crampton said they need to change their manuals because the manuals, officers' manuals, tell them to do a review and to consider all these factors. And so you're supposed to get those considered. And as you know, and as anybody who practices in this area knows, this has been the standard practice since IRPA came out, is that officers will give a fair warning and they say, we're going to consider this, and you're invited to make submissions. So now we don't know where it stands because the court has come up with a completely different interpretation. And the Chief Justice says, well, they're going to have to change the manuals accordingly.
So is this one of those cases, like, often people will come to us as lawyers and say, the immigration department or their manuals are unreasonable. We need to go to court so that a judge can review this. But is this one of those examples where the courts are actually seemingly much more strict or rigid than even the department and the department's manuals?
Yeah, and I suspect the CBSA is in a quandary right now. I mean, they know what was intended. They know what the Joan Atkinson said to the Parliamentary Committee in 2001, that the intention was that officers would replace tribunals in making these reviews, and that would be the role of the officer. And in Section 44, the Parliament expressly put in the word may. They may make a referral to a hearing. They may forward the case to a hearing, or they may recommend it go to a hearing. But it wasn't compulsory. Now, what the court's done is interpret may to mean shall. They're saying that the officers don't have discretion. May doesn't mean may, and which is odd because this is coming from relatively conservative judges who pride themselves, I would think, on being strict constructionists. But in this particular case, they've taken the express wording of Parliament and the intention of Parliament that there be discretion and twisted around to say, it really means that there's no discretion.
Even looking at the manuals as they stand today, so I'm talking about Enforcement Manual 6, they keep whittling down what the scope of the discretion is. And that's something that I think we've been seeing over the years, that, based on the jurisprudence, the scope of the discretion, I feel like normally when we see a manual kind of talking about the scope of discretion being reduced, I feel that I'm seeing fettering happening. And so when you see a word like may in legislation, to me, that's an open may. That means it's an open discretion. There should be a full exercise, as you're saying, Michael, especially when there has been the loss of appeal rights. So I can't help but go back to the kind of purposive question, like, why have we taken away those appeal rights if we haven't replaced it with a full substantive review? And so that to me is where the tension really lies. And, I'm with you in finding this resolution very unsatisfactory, that there is no discretion and no appeal, which just means that in situations like this, where there is a very meritorious claim and there are significant humanitarian and compassionate factors, there's just no relief.
It's, personally, it's really maddening for me because of the legislative history. And I was personally very involved in it. I was the CBA's national chair at the time that this legislation was introduced and debated, and we made extensive submissions. I had extensive meetings with executive, most notably Gordon Maynard was involved in that debate with him on this very provision. And we were concerned then that it wasn't explicit enough, and that the courts and the department would whittle away at it, as they have in fact done. And we said, you've got to put something in this more clearly in the statute. They didn't do that. They didn't make that change. They made some other changes here and there, but the assurance was very, very blatant, very clear and direct, that there would be a full review of all the circumstances by senior officers. And in the case of long-term permanent residents, it would happen at a very high level.
So I've
Well,
pulled
first-
open the
Actually, I
manual that
remember
we're
that.
referring to, and here you can see like it still refers to considering personal circumstances, which is, I guess, part of what the courts are saying need to be removed from the manual.
Yeah,
Yeah,
that's what. Yeah, go ahead.
sorry, no, I was looking at that part too, Steve, and I remember when I was reviewing it in the context of a recent case, there are a lot of howevers. However, in cases involving organized criminality, it is generally considered to be best that it's left to the board. However, and there are lots of, and so I do think that they are still trying to keep that minimal. But I just wanted to comment that I absolutely remember, Michael, when you and Gordon were making those submissions. I believe it was at the time when I was on the executive with the CBA. And I remember in those meetings saying, no, it's absolutely not our intention to remove that examination, and please don't be concerned about this. These submissions are still going to be heard. This is not their plan. And that you and Gordon were very preoccupied with, yes, but then we want to have that as something that's preserved in the legislation and not left to this vague promise.
Yeah, no, I remember the minister made personal assurances about this very provision, and it had a lot to do with her own personal history of the just desserts case, where somebody was killed by, arguably by somebody who was on an administrative stay or issued by the IAD. But in any event, she was absolutely adamant. And then what happened after that, of course, is that the department split into two departments: immigration and then the CBSA, the enforcement. And the whole culture changed, and the immigration minister lost control of that process. It became part of a CBSA process. And then you've got the enforcement cops who are exercising this quasi-judicial function that was originally intended. And so it's the process has been preserved to a great extent, except that the attitude that comes with it is far less forgiving. That's what we're seeing. And now the courts are basically saying, you don't have to do it. You don't have to consider anything. And your reasons don't have to deal with any of the evidence, because that's not your job. They've taken that job away from officers. So it's the Supreme Court may weigh in. Hopefully they will. I really do hope that they grant leave on that case, because I think it's important. Because it does affect the rights of permanent residents in lots of other situations, but certainly with any of the admissibilities. And we're all up in the air right now as to where we can go with what the remedies are. The Federal Court of Appeal in the case called Lynn said that it's premature to raise these issues at federal court. You have to make your arguments at the immigration division. And then JR that decision. Now that was not for this particular kind of a case, but that's people who had appeal rights. They said for people who have appeal rights. But we know that DOJ is considering expanding their argument of prematurity to apply to across the board, whether or not you have appeal rights. So there's some uncertainty, but none of it favors the immigrant.
Yeah, so I've just pulled up what the state of the law is now, according to Chief Justice Crampton. So the principles, and you've articulated them already, but it's just here's kind of a neat summary, is that the scope of discretion held by immigration officers and ministerial delegates is very limited, especially in cases of serious criminality and organized crime. And as you noted, they're on a fact-finding mission, not regarding a person's personal circumstances, but rather just the offense, whether there was a sentence, what the sentence was. They are specifically not to consider humanitarian and compassionate considerations. And they're only meant to look into readily and objectively ascertainable facts, and this applies to both foreign nationals and permanent residents.
Right, that's his takeaways, and those are all basically going out from the Obaz case, comments made throughout the Obaz case, but they're mostly picking up on previous statements made in cases like Cha and Sharma, which were statements that were made that were obiter, and there was a fair amount of agreement in the courts that the law was all over the place, that there were different competing decisions. And the Chief Justice in his own decision in McAlpin said, the law is unsettled here. Federal Court of Appeal is going to have to settle it. Well, Federal Court of Appeal, when they got the case, the Obaz case, they said, what are you talking about? It's all well settled. This case should never have even been certified. I mean, they slapped down the judge who certified the question for even certifying the question, and that's going to have a chill effect. It's going to be very hard for us to get certified questions in anything to do with these sections now.
I think we should just pause quickly to explain what a certified question is, which is, I think, unique in immigration, and you can correct me if I'm wrong, but I think it's unique in immigration that there's no ability to appeal generally a federal court decision unless the judge certifies a question of general importance. So in this case, Chief Justice Crampton didn't certify a question of general importance, so you can't appeal in this case.
That's correct, and in light of the Obaz case, not a surprise. I mean, the Court of Appeal, I thought that was unfair. I think there definitely was uncertainty in the law, and it's just wrong to say that it was clear, because if you look at, for instance, the Hernandez case, which has never been expressly overruled, Madam Justice Snyder, that stood for years as the definitive case, which said that there had to be consideration, that PRs deserve more consideration than foreign nationals, but there had to be consideration of all the circumstances of the case. The question was certified in that case. The Department of Justice chose not to pursue it, and so thereby accepted this as a defining law. Now, in the Obaz case, the Court of Appeal actually says the law is all well settled, and cites Hernandez has been one of the cases that suggests that, without explaining how Hernandez says something completely different. And Hernandez is the one case that focuses on the parliamentary intent. That is what the minister said to Parliament, and that informs Justice Snyder's reading in Hernandez. It's not addressed at all in the Obaz case. In Mr. Sidhu's case, the Chief Justice says, well, notwithstanding that, and he's very clear about it, notwithstanding that the minister said all these things and intended something to happen, that's now been displaced by the court's interpretation. Too bad, so sad. What they told Parliament is irrelevant in effect, because the courts have now pronounced. Even though I can't see that in the Obaz case that the Court of Appeal gave any consideration whatsoever, and I don't even know that it was argued in terms of parliamentary intent.
There's something else that I wanted to, going back to the first argument that you raised about where you're talking about the reference to public opinion. I had challenges with this argument as well, and with the way that the court dealt with that, saying that the reference to public opinion and to the negative letters had no bearing on the decision maker's final decision. I had a really hard time following the logic in this portion of the decision, because if Vavilov is telling us that we're supposed to give meaning to the reasons as they were written by the decision maker, and absent any extrapolation by the court, what meaning is to be given to the fact that the decision maker made reference to the negative letters that were received, if not for the fact that that influenced the decision maker in rendering a negative decision? To me, it's very hard to understand what bearing that had if they were mentioned but had no impact on the decision. To me, it's just it's not logical.
Well, it was even worse than that. We had submitted with our, as I said, extensive submissions. We had received hundreds of letters of support, like as against maybe two that were negative, and they were racist. They were really, you know, they were not pretty, but hundreds of letters of support, many from very prominent Canadians, some well-known, some former judges, some profs, senior departmental officials who are retired now, all kinds of people who wrote letters of support. We gave a representative sampling and said, we've got hundreds more we can provide you. The officer dismissed those letters and saying, we have far more letters that have come in advocating in the opposite. And we said, show us those letters. This procedural fairness demands that you show us these letters, and that there was a lack of procedural fairness that they didn't show us letters, including one by Michael Cooper, an MP, who was advocating for their removal. When we finally got the trial record, we found out that they only received about, I think it was something like 22 letters, and 12 of them were in support of Mr. Sidu. So in dismissing all of the public support, which is, I argue, a reflection of what a reasonable Canadian would think about this case, and you know, whether they would want to grant relief. In dismissing them, the officer deliberately misstated the facts, and Chief Justice he just says, no, it doesn't matter because his public opinion is irrelevant, and so it doesn't matter. He doesn't have to consider them. But it's a case where the officer seems to create the impression that he did consider public opinion, and he felt that the public opinion was overwhelmingly against Mr. Sidhu, which was not reflected in the evidence. But there we are.
And so where is, like, what are Mr. Sidhu's next steps? Because the Chief Justice makes reference to the fact that he can apply or reapply for permanent residence through humanitarian and compassionate grounds. It's not really a stream, but I guess we'll call it a specific stream. And so I got one question, which was, what would that actually look like for him? And during that period between any loss of status and when he submits an application or when it's decided, what status and rights would he have in Canada?
So, and this is the problem with that process, is that you can't make that application for permanent residence on humanitarian and compassionate grounds unless you're not a permanent resident. So you have to wait until after the hearing. So there will be a hearing scheduled in the next couple of months, just waiting for the notice to come out. And at that hearing, presumably they will take away his permanent resident status. At that point, he can file an application to get permanent residence on humanitarian grounds. But that's an application that goes to IRCC, not the CBSA. And they do have a mandate to consider these circumstances. The courts have not taken that away from them yet, and neither has Parliament. In Section 36, Parliament took it away in certain other sections dealing with organized crime, for instance, but not with criminality. So anyway, he can make this application, but he's removable. They don't have to keep him in Canada. In fact, the Department of Justice frequently argues that it doesn't matter if we remove the person because his application will still be considered in due course.
And during that time, he can't work.
And during that time, he will have no work permit. He can apply for a work permit. He can apply for temporary resident permit and work permit. And if there is a provision that says if you're not removal ready, they can issue a work permit. There's a couple of problems with that, in that he is given the opportunity to make a pre-removal risk assessment, arguing risk that he faces if removed, and they cannot remove during that process. That process usually takes a few months. So, you know, probably will be taking advantage of that process and filing an application for permanent residence on humanitarian grounds.
This is something we've talked about in the past, though, that removal proceedings are fast and IRCC proceedings are slow. So typical processing time for a TRP or an agency application is generally in the ballpark of a year unless something miraculous happens, and removal proceedings generally occur within the space of weeks or months.
Yeah, and you've got, the challenge is that the act specifically was amended in, I think, 2013 to say that they must remove as soon as possible. It used to be as soon as reasonably practicable, which allowed them a lot more flexibility. Now it says as soon as possible, and so and the courts have commented on it many times. The opportunity for deferral of removal is only short term and only for in rare circumstances.
Yeah, and I think this is an important caveat that didn't get understandably, the media, just saw that line. So like I've pulled up one CBC article which just says that Mr. Sidu now it says Mr. Sidu now faces removal to India after spending years of hard work establishing a life with his wife in Canada. The judge added that Sidu can still ask to be allowed to stay on humanitarian and compassionate grounds. And understandably, the media aren't immigration experts, but I just found that like lines like that made it seem like, oh, there's just another step. The guy can continue to be here. He can continue to work. He can continue to live his life while there's yet another step. While in reality, as you both pointed out, he can't work. He has no status during that time. He could be removed. It's not like it's just this automatic next step that occurs in the process.
No, people often characterize it, and you see it in judicial decisions sometimes. Oh, there's other remedies available. Well, there's not much available actually for people in this situation. It's the humanitarian compassionate is the one, especially now in light of what the courts have just said regarding the Section 44 review. It would appear that the humanitarian application is really the only thing you have left, and that. Like you say, you're not allowed to work. You have no status, and you're subject to removal on pretty short notice.
And then, as you mentioned, like going forward, it's a bit of a odd jam that even CBSA could be in, because they can't just amend their manuals to say officers can consider humanitarian compassionate grounds if a minister wanted such a policy, because as you note, the courts have said that that's not what the law says. It's going to be hard, given the Federal Court of Appeal decision, for federal court judges to change the law. So really, like, if the government did at this point want to reintroduce the ability of CBSA officers to be able to consider all factors without, just telling CBSA officers to ignore the law, it would take an actual regulatory amendment?
It would take an amendment to the act. That's because it's a rights issue. So it's got to be in the act, not the regs. And so, I mean, I think this is a case where the Canadian Bar Association and other groups who are representing immigrants have to be pushing for legislative change. This legislative change actually should have happened a few years ago. In 2013, when they introduced the Faster Removal of Foreign Criminals Act, they brought in a bunch of draconian provisions that, even though the federal government under the Liberal government has overturned much of what they did in the criminal justice areas, such as mandatory minimum sentences, they have done precious little on the immigration front. And we have seen the rights of permanent residents, especially, but immigrants in general, foreign nationals too, greatly diminished. And this is like another nail in the coffin. These judicial decisions are, and they follow a trend. And I think of an unfortunate trend at the Court of Appeal, which is that it seems the decisions always go against the rights of the immigrant. They always side with the federal government, and it's discouraging. But I think it requires Parliament to get involved.
Why do you think there's been so little action? Like when the Liberals first came in almost a decade ago, they quickly amended the Citizenship Act, and they haven't done an immigration specific bill I don't think there has been an immigration specific bill since they came to power almost a decade ago. There's been tinkering with express entry and omnibus budget bills, but no comprehensive immigration act amendments.
No, particularly dealing with the enforcement side, the rights side, the due process side, there has been nothing, and it's very discouraging. We've had a revolving door of relatively junior ministers come in. John McCallum gave us great hope when he came in because he was very knowledgeable, very experienced. He had been the immigration critic for years, and he did have the strength to make changes. But he got sacked, and we've had since then. I don't think anybody who has had a really strong understanding of these aspects, the rights aspects, since then.
The last visionary we had was Kenny, and he was the one who really spearheaded the taking away of many of these appeal mechanisms and procedural rights. But I'm 100% with you, Michael, that for me, there's no explanation for why you would be removing a right of appeal, why there would be no ability for a permanent resident to have an equitable, to argue the equitable side of their appeal before loss of permanent resident status. I can't get my head around it.
So you go back and read the Obaz case again, and you're going to have just as hard a time. The judge says something to the effect of it's hard to believe that Parliament would go to so much trouble crafting these provisions that limit your appeal rights, and then want to give officers discretion. Well, that's exactly what they wanted to do. That's what they intended to do. It's not baffling at all. But it's baffling to the Court of Appeal, and it's somehow they read in the fact that they restricted appeal rates as meaning they wiped out any consideration whatsoever, which is not the intention.
Well, and the minute you start reading this decision, that there's sort of an apologetic tone to the decision, that, I understand this is not the decision that the public is going to be hoping for. And, however, I am just reading the rules as they're written, and I'm interpreting this in the context of the Vavilov decision. And this is just not, this decision was not unreasonable. There you have it. And I feel like this approach to rights in the immigration sector is just so disappointing and so discouraging. The line that hard cases make for bad law. I feel like we've just been closed in by this lack of rights approach. That really we've dwindled it down to virtually nothing, where an outcome that is despicable to so many is still the prevailing decision.
When you read this, those four principles that you just quoted, that the Chief Justice tried to distill from the Obaz case, it's essentially says that permanent residents have no more rights than foreign nationals. So a person who's illegally here and commits a crime is entitled to the same level of review as a permanent resident who may have come to Canada as an infant, be a complete product of Canadian society, have made one single mistake in an otherwise stellar life. And that person gets only the same consideration as the illegal who just came in and broke the law. That's baffling. And it's really indicative of, I think, a need to change, because I don't think that Parliament intended permanent residents to have so few rights. I think that we look at some of the other things that happened that we were successful in getting at the time that IRPA came in. For instance, the right to remain silent. Their original draft, it wasn't there. Permanent residents were compellable and had to answer all questions truthfully. We got them to limit that to in cases only where there's applications, where they're making an application. They can't pick you up on the street now and demand that you answer questions.
Yeah, I also find, and it may be a theme this year or started last year, because I think I touched on this in Mason, but there's also this weird disconnect between what the politicians will say to the media versus what goes on, and they can almost deflect and say, well, that's the civil service and the court. So for example, in this case, I can't imagine Trudeau or Mark Miller, standing up before the press and saying, we don't want permanent residents to have their rights or their individual factors considered before we take their permanent residence. Yet the bureaucracy in the courts will move that way. It's a very recent case, but the espionage case of where the federal court and the department have now found that it's reasonable that someone can be inadmissible for espionage because they may be coerced in the future. I can't imagine at the political level, either again, the prime minister or Mark Miller standing up saying, yes, people should be. And then the Mason decision, which received very little media attention, but the idea that, and you didn't see at the political level any of the current government standing up and saying, we want permanent residents to not have to be convicted before we can deport them. We want to just, if we think that they may commit violence, that should be enough. They don't say that publicly, yet the bureaucracy in the courts move in that direction, although the Supreme Court overturned it, without the politicians normally commenting. And it always makes me wonder, like, do they either secretly support what's going on and is there quiet guidance, or are they just oblivious to like the mechanisms of how the civil service and the courts are evolving the law?
One more like this, which is, and I don't remember if it's you that brought this up, Steve, was this conversation about when does it become homegrown crime? At what point do we take responsibility for crime that is committed based on somebody's being here in Canada? I feel like I don't know who it was, like Douglas Adams or something, who came up with this phrase that this is an SEP, this is somebody else's problem, that when somebody comes here, they might have lived here for all of their life, but then, as Michael says, they commit one mistake, and that mistake might have been caused by a difficult life that they experienced here in Canada, sometimes because of a tortured immigration process. One mistake and you're off, somebody else's problem, but there's no acknowledgement or recognition for the fact that the conditions that created the criminality were Canadian, not foreign. And so there's no sense of ownership, no accountability, no sense of our being responsible for rehabilitating that person at all. And I think, again, this like, okay, we're done with you, over to the country of origin.
And there's been pushback from some countries about the level to which we and the United States to some extent you dump our problems, which are really our own created problems.
Yes.
It's just the luck of the fact that the person didn't become a citizen. Sometimes these people thought that I've had clients who thought they were citizens. They thought they got their citizenship when their children. They just didn't realize their parents never applied for them, and here they're getting deported. And much later. I think unfortunately that it's what so often happens in politics is where are the votes? Kenny could sell this kind of tough on crime agenda to his base because that's what they wanted, was tough on crime, and that included immigrant crime, especially immigrant crime.
For sure. You take mothers away from their kids in order to give caregivers, and then, you're not prepared to live with the consequences, the social consequences that you're creating because of that. And again, the tough on crime agenda sells, but again, there's a dissonance between.
I think, Kenny could sell that to his voters. They were probably even more progressive on immigration than much of the base. It's the current government that I find, because everything that I described has happened under the current government, and kind of the silence at the political level, outside of like an individual MP writing a letter here or there, has just puzzled me.
Agreed.
It'd be interesting to know what discussions, if any, are happening in the minister's office over this area. I'm sure they are having to look at, do we have to amend the manuals to reflect these court decisions? But who's looking at this and saying, is this right? Is this what we really intended to and what we want to do? And I'm hoping that they're saying this needs a fix because it's wrong. This is dead wrong. They should not be. I don't think the intention was that the Parliament intended there'd be one strike, you're out with no consideration of your circumstances. That's ridiculous. In fact, they said everything other than that to Parliament when they put this through. But you know, here we are, and so hopefully there will be some political will to do something, because unless the Supreme Court hears the case and sets it straight, I think we're doomed to a situation for probably several years where PRs will have no rights.
Yeah, but Michael, I think it bears repeating that unless this change is made at the legislative level, then I think we really are lost. I think changes to policy manuals. I know that there's a real push from advocates to do this through litigation, and I obviously that's laudable. But at the same time, I think that we need this in black and white so that the intention is there.
I think if you read, you know, anybody who wants to say, "Oh, let's do this all through litigation," should go read the Obas case and see, you know, how much hope you have for winning at the Federal Court of Appeal on an immigration case. You know, I don't think that's where the solution lies. There's, you know, correct me if I'm wrong, but I don't think there's ever been a former immigration lawyer on the Court of Appeal. Not that I'm aware of, and there's only recently been any immigration lawyers on the federal court. So that does color things. It just does. It's
especially given what you said about the likelihood of getting leave to go further to the Supreme Court of Canada.
Yeah. Well, just getting to the Court of Appeal in the first place, especially the chill effect of that Obas decision is going to have on federal court judges. I mean, they're going to have to think really, like, do I dare get myself slapped down for certifying a question here in light of what was said there? So it's no, I don't think litigation is going to be the solution. They, interestingly, in Obas, they wanted to argue Section 7. And the court said, no, it's premature. You didn't raise, or so you didn't raise it before the immigration officer. Therefore, you can't raise it to the federal court, which I thought was astounding, and I can't believe that's correct in law.
Yeah,
but actually said it, you know, and you know, raising it at the officer level. This is contrary to Section 7.
Oh my God!
You're not going to get a constitutional determination by an immigration officer. That's not going to happen. And even the immigration division, I don't have a lot of hope for if you want to challenge the whole system at that level. But in any event, here we are, and it seems the courts have shut down even the constitutional argument, made it very difficult to make that argument. So we're back at the minister here. You know, this is where the change had to be made.
And to bring this back around to like access to justice. So you're talking about an individual applicant is supposed to have the wherewithal to make constitutional arguments. Well, like, honestly, what kind of a justice system are we talking about?
Well, and you know, so this has always been a bone of contention for me about, you know, the procedural fairness of the existing system that has just been struck down anyway. But quite often we'll get served with a letter while they're incarcerated. Many of these people don't, they're immigrants who don't speak good English in the first place. And so they don't even understand what they're getting. And I've seen so many of those over the years where they get this letter saying, tell us all about yourself, because we're trying to decide whether we should deport you. And they don't tell them, go get a lawyer, get some legal advice. Nothing. And so often the submissions that get made are so weak and unsubstantiated that they don't have a chance in that process. Well, now that process it looks like even that process is being gutted because we're not even sure they have to give them those letters anymore.
And this is leaving aside financial means to make that kind of plea, leaving aside mental health issues in terms of like, how are you doing psychologically during a period of incarceration, you know, especially if you are truly feeling remorse, which is it's not going to be a pretty period of time when you're receiving that letter, you know.
But most of I hate to say it, so often I've had people who didn't understand the letter and didn't realize this is their only kick at it. This is, if that decision goes against them, they're out.
Yeah. But I've had clients who are so racked by remorse and so gutted that they actually at that stage can't really grasp the full consequences, and they don't actually they're not able to, they feel so guilty you know, and so it's just that doesn't it doesn't put them in a right frame of mind to understand what the full weight of the consequences are if this is just allowed to roll over them.
Well, that was Mr. Sidhu, I believe. Every media story that I've seen about this talks about how unbelievably remorseful he immediately was. He
Exactly.
immediately pled guilty.
That's kind of why I'm
Um,
raising it here. Yeah,
yeah.
it's
No,
just
you pointed out, it's the case. He, he was racked with remorse and pled guilty to everything, even though it would have been much better from a legal standpoint to fight it and try to do a plea bargain. So many of these uncontrolled intersection cases end up in a careless driving conviction under the Provincial Traffic Act. That's what Premier Scott Moe got for going through a stop sign and killing somebody. Careless driving. That's the way they've usually been dealt with by the courts. But he might have been able to get it himself. But who knows? I mean, this case is unique and it's horrific, and who knows if they would have done that kind of decision. But he didn't even try, and that's so often the case that people don't try because of the state of mind they're in at the time.
But his conscience and his morals drove him to like accept the consequences of his conviction, and it's had such huge consequences for him. And there's no recognition of that, and there's no balancing that happens in the immigration process as a result.
Especially as a result of these decisions, too.
For sure,
In
exactly.
this case, because there was some balancing, an effort at the balancing by the officer. We didn't think it went far enough. We didn't think it was fair. Chief Justice said it was fair, but he didn't even have to do that. He said that the law is settled. You don't even have to do that balancing. So it's,
it feels a bit like double jeopardy in a way. You're punished for the crime and then you're punished for the crime. And
well, and the process by which we take away somebody's permanent residence, I would like to think we'd have a just process, but according to the courts, there's no justice required at all. Basically, that it's just an automatic decision, a mechanical decision, if you will. And I can't believe that that's what Parliament intended, but that's how the courts have interpreted.
Do you think, and maybe we'll wrap on this, that it should just be decided at the criminal stage whether someone loses their permanent residence as part of the criminal sentence, and just collapse it all into one thing instead of having sentence and then a whole process for immigration, just dealing with it all at the outset?
No. Sometimes there's a couple things here, but sometimes these removal proceedings happen long after the criminal event. Sometimes the criminal event itself doesn't get dealt with by the courts for many, many years. Sometimes it goes through an appeal process, whatever. So the circumstances, I think it's important to look at the circumstances that are current rather than as they existed at the time of the offense. And I think that's all relevant. And there are all kinds of factors that come into play here. I want to raise one other thing too, is that the implications of this. We talk about people, the convictions in Canada under Section 36(1), but 1A. But there are foreign convictions come into play here, and also the fact that somebody may have committed a crime in a foreign jurisdiction can lead to inadmissibilities. And so something as simple as, let's say a person gets convicted of impaired driving, or pleads guilty to impaired driving, and they're a permanent resident. They do it in another jurisdiction, let's say in the United States when they're on holidays. That person can now be stripped of permanent resident status without any consideration of the circumstances of their case. Same thing with committing an offense in another jurisdiction. So
it's funny you should raise that, because the immigration story today, I guess, and I feel like there's a bit possibly of a misunderstanding going on, is that according to CBC, there's someone was convicted in absentia in Russia of spreading false information about the war in Ukraine, and she was pulled aside during her citizenship ceremony and said that they would have to be their citizenships, she wouldn't be able to do the oath, and she was getting a PFL saying we need to determine if there's equivalency and all that. Now, I assume in this case that once they have all the information about what led to her being convicted in absentia in Russia, that it doesn't equate to spreading false information under the Canadian Criminal Code. I mean, that's what I hope, but it does kind of serve as an example of what you're saying, where foreign convictions could impact someone's permanent resident
But
status.
it's not just convictions, remember, it's if an officer has reasonable grounds to believe
Reasonable grounds.
committed an offense.
Mhm.
And so I've got one of these. That guy was pulled in off of his citizenship the day before his citizenship's oath ceremony because of allegations made in a country that has a reputation, recent reputation, for interfering in our domestic affairs, including possibly carrying out targeted killings. Now, this guy is on the wrong side of certain influential people in the government. We believe that's what's behind this. But all they have to do is an officer just has conclude. I believe there's reasonable grounds to support the conclusion that he committed an offense, even though we're saying he's framed. And bang, he not only loses his chance at citizenship, he gets stripped of his permanent residence status and can be removed from Canada with no right to any kind of a hearing process. It's more than a little disturbing. I misstate he would get a right to go to the immigration division to have that determination made on a 36(1)(c), but that's it. That would not consider its personal circumstances at all, only whether or not he had reasonable grounds to believe he committed the offense.
Mhm.
So there are
Yeah,
some
that's interesting.
far-reaching implications for something like this. It could be, you don't even need a conviction for impaired driving. You could have just, if an officer concludes that they believe they saw
You
the
did
police report and they believe you committed the offense.
No, I think this, I think I was telling Deanna, I think that 2024 is going to be probably the year of different security or enforcement type stories. Like we have upcoming episodes on the new inadmissibility provisions due to sanctions and what that could mean. There's this Chinese espionage decision that came down, and it just seems like,
We're
kind of
filling our
mirroring the
calendar very
geopolitical,
quickly.
yeah, the geopolitical landscape. You mentioned a country that may have ordered a assassination on Canadian soil and the possible repercussions of that this year as that unwinds.
Mhm.
It's gonna be quite a year, I think.
Mhm.
Yeah, and I mean, I wish I could just say that it was all rosy and that we're going to see all kinds of victories for justice and due process. I worry about this,
No.
these cases being in harbingers of a different shift that's been happening, especially in the courts.
Yeah, we're all putting on our seatbelts for sure.
Yeah.
Yeah.
Well, thanks for coming on. I know you've been up early after getting home from Victoria. So
Mm.
I just want to say one other thing is that, what's been heartwarming in this Sidu case has been the outpouring of support,
Aw.
both, you know, from people in the legal field, and the justice field, but then on a very personal level, especially for my clients. I don't know, it's well known, but my clients they had a baby in April, and that child has had severe medical problems, like
Oh my God.
problems. Spent like first 13 weeks in ICU, that kind of stuff, and it's an ongoing thing. So there's best interest of the child issues that just unfortunately are here, and not by design. It's just unfortunately part of it. They have been pretty buoyed by the support they've gotten from a lot of people, and I just hope that that continues.
Oh, Michael, thank you for sharing that. That's poor family, honestly. Like this case really, I think, some of these issues that we know very intimately, I understand they're very complex and they take a lot of teasing apart because of all of the nuances of immigration law. But something about this case really brings it down to the human element. Bad things happen to good people sometimes, and I think it really does help distill at a very basic level what's wrong with our immigration system right now. Anyways, I really appreciate the time that you've spent with us today, and I think it's helped clarify a lot.
well, yeah, I can wrap with an email that I got when I said we were having you on, and I won't name the person who emailed, but they initially wrote to just say, oh, is there also a petition going around to sign to keep the subject from deportation? To which I said, no, do you happen to know Mr. Sidhu? And this person just wrote, No, I do not know him personally. I would just like to support him in not being deported. It is tragic what has happened, but I am sure he will be paying mentally for the rest of his life, along with the jail record. Please keep me informed of any petitions circulating, of which I don't know of any, but maybe
There
you do.
was a petition, I haven't seen, what's become of it. It was just a private initiative that somebody started up quite, a couple of years ago, I think. I'm not sure where it's at. There's a fundraiser. It's not GoFundMe because GoFundMe, they went on there and they got kicked off right away. I think somebody objected, let's just say, but they've got it under another platform called fundraising, that they've been able to raise some funds.
Okay, well, if I see it, I'll link to it in the show notes.
Yeah. Good on you for doing this work, Michael. It's a hard one.